We'll cover what it is, the potential penalties, and some common defenses. Understanding these aspects can be crucial if you or someone you know is facing such charges. What is larceny by stealing? Larceny by stealing, as defined under Massachusetts law, involves the unlawful taking and carrying away of someone else's property with the intent to permanently deprive them of it. The prosecution must prove three elements beyond a reasonable doubt. First, the defendant took and carried away property. Second, the property was owned or possessed by someone other than the defendant. And third, the defendant intended to permanently deprive the owner of the property. Potential penalties. The penalties for larceny by stealing in Massachusetts can vary significantly based on the value of the stolen property and other factors. Misdemeanor larceny. If the stolen property is valued at $1,200 or less, the offense is considered a misdemeanor. Penalties can include up to 1 year in jail and a fine of up to $1,500. Felony larceny. If the property is worth more than $1,200, it is classified as a felony. This can result in up to 5 years in state prison, a fine of up to $25,000, or up to 2 years in jail. Special circumstances. Certain types of larceny carry harsher penalties. Stealing from a person 60 years or older or a disabled person. If the value of the property exceeds $250, penalties can include up to 10 years in state prison or a fine of up to $50,000. If the value is $250 or less, penalties can include up to 2.5 years in jail or a fine of up to $1,000. Stealing a firearm. This is always a felony, punishable by up to 5 years in state prison or a fine of up to $25,000 and up to 2 years in jail. Facing a larceny charge can be daunting, but several defenses might apply depending on the circumstances. One of the most fundamental defenses is proving a lack of intent to permanently deprive the owner of the property. If you can show that you did not intend to keep the property permanently, you might avoid a conviction. If you honestly believed that you had a legal right to the property, this could serve as a defense. Even if this belief was mistaken, it can negate the intent required for larceny. If you were induced by law enforcement to commit the crime that you otherwise would not have committed, entrapment could be a valid defense. If the property owner consented to you taking the property, this could also serve as a defense. The prosecution must prove that the taking was without the owner's consent. In some cases, if you were intoxicated and lacked the intent to steal, this could be a defense. However, this defense can be complex and requires substantial proof. If you or someone you know is facing larceny charges, it's crucial to understand the potential penalties and defenses. Consulting with an experienced criminal defense attorney can make a significant difference in the outcome of your case. Attorney Patrick Donovan is here to help you navigate these challenging situations. Contact us today for a consultation. Thank you.